So I'm on good authority that Kate's attorney is actually doing work for her pro bono. So makes sense since her, supposed $18,000 fundraiser thing was completely fake. So she went and also explains why it took her so long to find an attorney. She was trying to find a pro bono, quote unquote, First Amendment attorney, and she found one. So when she says she put down a retainer, what she actually meant was she probably gave them the cash money that it takes to file an answer to the court. So she gave him like the $400, whatever it takes. It's also interesting in Kate's last video, when Dog Detective asks, "Did your attorney say anything?" And Kate says, and notice how many she says, because you guys trolls give me a hard time with my ums. But Kate says, quote, and I quote, no, but even if he did, I would not do that. Like I said before, I'm not going to F up here and, violate the attorney client privilege that I'm entitled to. So, any discussion that I have with my attorney, nobody's going to know about it except for me and my attorney. That's how that works, end quote. So, maybe she says, when she's lying. I don't know, but I suspect if you ask her if her attorney's pro bono, she's going to exercise her client attorney privilege. It's also interesting that in her last video, she says that she never received a cease and desist letter from Chile. So it sounds like that's the defense she's going with, right? That Chile never asked her to take them down. So, I don't know. Interesting. So, with that in mind, we're going to cover pro bono attorney strategies today. So let's go over the cost of pro bono services. So if you have a pro bono attorney, or if you can also use this to run up costs, right, of your opposing parties' pro bono services. So most pro bono contracts don't pay for copy fees, postage, and filing fees. Most attorneys are only required to do 25 hours of pro bono work a year. Because they're not paying filing fees, it costs about $400 to file a complaint or answer in court. Costs about $100 for the attorney to file a notice of appearance. Kate probably had to pay for that too. Service by mail will cost money due to copy and postage. Most state courts charge fees for motions in the $20 to $60 range. Yeah, it doesn't apply to Kate and Chile in this lawsuit. So telephone calls with a licensed attorney will cost more than email from an assistant. So the pro bono agreements are usually limited in scope. The attorney can't abandon you halfway through once they reach their 25 hours. But a plan will be laid out, and anything beyond that plan will not be covered. The plan will avoid dispositive motions to dismiss. Will usually be avoided. I worded that weird. Focusing on winning on merits. So Chile can look forward to that, right? That the plan is probably just going to involve an answer. He's not going to have to fight a motion for failure to state a claim or motion for summary disposition, which, wouldn't work anyway. And then defendant counter complaints usually not be included in the plan. I mean, I say usually, but they won't be included in the plan. So Chile doesn't have to worry about being sued in return. So there's usually an early termination clause as well. If evidence shows a lack of legal grounds, the attorney will withdraw. So right now, the attorney only has Kate's, side of the story, and alleged facts in the complaint. Although It was an affidavit as well because Chile signed it as such. So, once he gets once he actually watches the video or gets expert documentation or expert transcription of the video, and it's obvious that it's defamation, that he could likely withdraw. If the client lies to the attorney will withdraw. I'm not going to guess at some of the lies that she might already be telling him, but since the attorney's still on her side, it's likely that he hasn't been told the whole truth. So don't destroy evidence or do anything that will lead to sanctions against the attorney. That will definitely cause him to withdraw. So how do we make it fair if the other party has a pro bono attorney? So federal circuits and state courts were ghostwriting, which is where an attorney prepares or reviews documents for a pro se party, and pro se is someone who's representing themselves without an attorney. So ghostwriting is normally not allowed, but a court may allow it if you're pro se and the other side is receiving pro bono services. This doesn't apply in the First Circuit Court where Chile and Kate's lawsuit is. Ghostwriting services are already allowed there. Also, you can request pro bono services, especially for trial. So many state courts are required to request pro bono services for parties involved in complex cases that can't afford attorneys. In the federal court where Chile and Kate are, the federal court may request pro bono services for complex cases, but it's not required. That's all I got for you today. Let me know if you have any questions.